they're exchanging funds, that's the core.
I see my time has expired, so.
Gentleman's time has expired. Well, I'll go to the
Okay.
gentleman from Ohio, Mr. Davidson, for 5 minutes.
Chairman Gensler, recently a federal court called your rejection of a Bitcoin ETF, quote, arbitrary and capricious. In a subsequent interview, you dismissed the judge's opinion. Asked a follow-up question, if anything a judge says would change your mind, you responded, quote, well, no, not really. It seems that you don't really recognize the authority of the judicial branch. You seem to have a love for the Howey test, selectively applied as illustrated by Mr. Torres. But, you know, in light of those reactions, you know, what should people make about the Bitcoin ETF? How will the SEC revise its approach?
We have great respect for the courts. I personally have great respect for the courts. We're considering that. It's still an active consideration at the commission. And
So you haven't made up
we're
your mind. I got to
we're
tell you,
familiar with the case.
yeah, I got to tell you that many market participants have reached out and are concerned that you will arbitrarily, perhaps also capriciously, pull recent filings ahead of others who've been working with the SEC for years to get an approval for a Bitcoin spot ETF. Will this resemble some sort of free pass for one favored company while others remain locked out? And I ask that because it seems that's happened before at the SEC.
Sir, I'm not sure if I'm following. I mean, we're still considering that court case and the application, as you say, to Bitcoin exchange traded products.
Are you going to preserve people's place in line, or are you going to pull ahead a favored transaction or another on the consideration of a Bitcoin spot ETF? Are you going to preserve the place in the queue? Because timing matters. People have worked on this for years, and then you get a recent filing by somebody big in the market, and it seems like, oh, yeah, let me take your calls. How can I help? Meanwhile, you've given the stiff arm, as I've said, Hotel California style regulations where you can check in with the SEC, but you can never leave with clarity. You know, and how about the legislative branch? Do you recognize the authority of Congress or the laws that we pass?
Yes, we comply with the laws that Congress passes every day.
Well, I've heard you say that about the courts and now Congress, which is encouraging, but I am inclined to judge your deeds more than your words. And, you know, I'll pick up where one of my colleagues, Mr. Huizinga, left off with the Supreme Court decision in West Virginia versus the EPA. Are you familiar with that case?
Yes, sir, I'm familiar. It's an important case.
Glad to hear you say that. And it would be binding, correct?
It's the law of the land, sir.
That's right. And it introduces a major questions doctrine. And you told Mr. Barr that you received tons of feedback on your proposed ESG disclosure rules, feedback that should make clear that the proposal for ESG disclosure is a major question. And it should make clear that you don't have the legal authority to do that. So I'd ask you to knock it off, cease and desist, and work with this body to pass a law if you want to regulate something. You know, frankly, your time as chairman has highlighted two problems, a Gary Gensler problem and a structural flaw in the SEC. And as I told you in April, I proposed a solution called the SEC Stabilization Act. You're making the case for this bill easier every day you are acting as the chairman by doing rulemaking after rulemaking without any regard to the impact of these rules, or maybe that's the feature for you, I don't know. But it's having a massive impact on our markets. I mean, we have markets that truly are the envy of the world, and why would you disrupt them, you know, with processes that are driving capital out of our markets? Not because to avoid our laws, but to find some place where they can get clarity, where they can work with a regulator and get a decision in a path forward. So instead of selectively applied, you are you're not providing clarity with a rule that's evenly applied. You're intentionally shortened comment periods to limit feedback. And the courts have even called this arbitrary and capricious. You're pushing a woke political and social agenda, and I think abusing your role in the authority of the SEC as cover. So, you know, I think fundamentally the SEC Stabilization Act would remove the role of chairman. It would preserve the current commissioners, but it would add a sixth commissioner. So there would be no more than 3 from any one political party. And so that would provide a path that would make the SEC do what you're avoiding, Frankly, you're front-running Congress, you're front-running the courts, you're front-running even the own administration, and no one has held you to account for that. I mean, I wish the Biden administration would say you're fired, but the list of folks they need to do that for is long. Congress hopefully will with the SEC Stabilization Act. I yield.
Gentleman's time's expired. We'll now recognize the gentleman from Nevada, Mr. Horsford, for 5 minutes.
Thank you, Chairman, and to the ranking member for the hearing, to Chair Gensler for being here. While investor protection remains paramount for my colleagues and myself, it should not be lost on anyone here that the largest risk our investing public is exposed to at this moment is the risk of a government shutdown. We hear time and again in this committee that our capital markets are the deepest and most efficient in the world. And yet, a large part of why they were able to reach their presently enjoyed imminent status is because investors around the globe have confidence that the SEC has the power necessary to maintain fair and orderly markets. Without proper funding in place, the SEC cannot carry out that critical investor protection mandate. And I fear that as funding disruptions become increasingly more common, we risk losing the world's confidence. And so I'll continue working earnestly with my colleagues to avoid a counterproductive MAGA Republican inflicted government shutdown. But I ask all of my colleagues to consider the far-reaching consequences of this short-sighted path. Mr. Chairman Gensler, when we last spoke, I raised concerns regarding the open-end fund liquidity rule, and I appreciated your willingness to consider that the vast majority of my constituents do the bulk of their investing through their retirement plans. These hardworking Nevadans should not be at risk of losing out on today's price simply because they live on the West Coast. Chairman Gensler, as the SEC continues to evaluate its economic analysis for the open-end fund liquidity proposal, what have you been able to ascertain about the disparate impact for investors based on geographic location?
It's been raised by yourself, but it's been raised by members of the public.
Have you resolved it in the rule? And I only have 3 minutes.
I appreciate it. I'm not trying to prejudge where we will end up. The overall rule had 3 key parts. You're focused on one, which is what was called the close or hard close. But there are 2 other really important parts. Liquidity, just what is the liquidity behind?
So will the geographic location be factored in your final rule, yes or no?
It's an aspect of it, but it's still
I don't know why this dude can't
all
answer these
funds
regular
today
questions.
close at
Leave,
4
brother.
p.m. Eastern Standard Time.
Which
so it's already
disproportionately impacts Nevadans and
Already.
people on the West Coast. So I'm going to keep pressing the issue until you understand that it's a disparate impact on those of us who live on the West Coast. And Nevadans should not be treated unfairly because of where they live. That needs to be factored in the final rule.
I agree,
Chairman
sir.
Gensler, as Mr. Meeks pointed out earlier, minority and women-owned firms still tend to be smaller as they work to overcome their traditional underinvestment and lack of working capital. As you heard previously, these smaller, more diverse firms will have more difficulty complying with the new disclosures required and will have less ability to absorb the cost associated with doing so. Earlier, you had begun discussing the expanded analysis the SEC made for the disproportionate impact on diverse and women-owned funds when the Commission considered the private fund advisor rule. Would you be able to expand upon your earlier answer that these funds were included in the analysis of small business and give us any specifics that your team found on the potential impacts on these funds?
I'd be happy to have staff follow up with the actual pages and the parts of the economic analysis, but it was considered as part of the effects on small investment advisors, including women and firms of minority-held firms.
It is a waning diversity. The issue of waning diversity in our equity markets is of great concern, and we must be careful about adding any additional burdens on these small firms. And I look forward to working with the SEC specifically on this issue. As I said, it's a wider issue, Mr. Chairman, and I worry that at a time when attacks on diversity, equity, and inclusion initiatives, not woke, like my colleague just referred to, when the next time someone uses that word, will you define what you mean by it? Because to me, it means anti-diversity. It means anti-inclusion. And if that's what you stand for, then you don't represent me or my constituents. We are working hard to hold the line. There is nothing in any court decision by the Supreme Court or anywhere else
Tell them
that should quelch private sector's commitment to diversity, equity, and inclusion.
Tell them
We must use every tool available to us to not only bring new entrants into the financial system, but to also promote
Gentleman's time
their
has expired.
success
Right.
within our financial institutions as well. I will yield back at this time.
Gentleman yields. The gentleman from Tennessee, Mr. Rose, is now recognized for 5 minutes.
Thank you, and thank you, Chair Gensler, for taking time to leave your virtual office in Maryland to attend today's meeting. And I was also glad to see that you held an in-person open meeting last week for, I think, the first time during your chairmanship. I say that because, Chair Gensler, you are rarely in the office and conduct most of your meetings from the comfort of your home. And what I wonder is, how can we be sure of who you are meeting with on a daily basis? If perhaps someone from Better Markets comes over for dinner to discuss Europeanizing our U.S. capital markets, would that be logged and made publicly available on your calendar?
I haven't had any of those dinners, but hypothetically, if I had that dinner, it would be logged.
I hope so, and I'm glad to hear that. Chair Gensler, in your written testimony, you state that, quote, "We also have finalized 24 rulemakings, nearly all of which have changed based on public feedback," close quote. Approximately how many hours per week do you personally spend reading public comments submitted to the unprecedented number of proposed rulemakings issued by the SEC?
I work a lot of hours during the week. My kids are running out of the house. My girlfriend lives in a different city. So I don't know how it breaks out. I usually get summaries of the comments. But then staff gives me individual, if it's a member of Congress, I read all of the members of Congress comments personally. But then I get examples in each of the rulemakings, a handful on each of the issues.
Well, I'm glad to hear that as well. Chair Gensler, in May, I co-led a bipartisan letter to you along with my colleague Jennifer Wexton and 22 of our colleagues regarding troubling accusations that the China-backed fast fashion retailer Shein allegedly engages in human rights violations, including utilizing materials that may have been made using Uyghur forced labor. Do you believe that Shein should be required to certify via independent verification that the company does not use Uyghur forced labor as a condition of being registered to issue securities in the United States?
If I might step away from one registrant and go a little broader, Congress passed a law, the Uyghur Forced Labor Act, I think was the name. And that's the law of the land. And so if you're a registrant and you're getting supplies from that region of China, whether you're a US company or a China-based company, we put out guidance, the staff put out guidance earlier this year to all public registrants that they have to speak to if they're in compliance with that act of Congress. Again, materiality matters, and we've been very clear with that with individual registrants in their filings, and our Division of Corporation Finance makes that abundantly clear in each of those registrants' discussions.
Thank you, Mr. Chairman. I ask unanimous consent to have the text of that letter entered into the record.
Without objection.
Chair Gensler, regarding cryptocurrencies and shifting gears, I'm interested in why you have pursued a litigation-heavy strategy, despite the fact that neither you nor any of your senior staff are litigators, neither your chief of staff nor your policy director or even your general counsel. Why have you settled on such a litigation-heavy strategy to address the cryptocurrency market?
Frankly, it's because the field is so rife with hucksters and fraudsters and non-compliant parties, but we've also done rulemaking, one related to broker-dealers that was completed a number of years ago, and then others related to the definition of exchange and the custody rule that's been discussed a bit here, and even something called best execution. But this is a field where the American public's at risk and being harmed every day on these platforms that are commingling and trading, often trading against their customers.
Well, in my view, it seems that these cases are brought with an explicit political agenda, not a substantive legal one.
Nothing could be furthest from the truth. There's nothing, the only thing political is protecting the American public, which I think members on both sides of the aisle probably agree. They don't want to see constituents hurt in a place where a lot of crypto projects are not properly disclosing. There's been all too many bankruptcies, and in the bankruptcies, investors are just lining up at the bankruptcy court.
Well, thank you. In my opinion, I'd like to see you do more from the regulatory and guidance side because this industry is so important and we need to foster it, in my view. Thank you, and I yield back.
Gentleman yields back. The gentlewoman from Michigan, Ms. Tlaib, is now recognized for 5 minutes.
Thank you. Thank you, Chair Gensler, for being here. I know that you've been pretty public about the fact that or maybe you made an argument or took a position that it's too costly for firms if the SEC establish a robust climate disclosure rule. Is that correct?
There are many comments in our comment file that have raised that, and that's what I'm talking about, because we, under the Administrative Procedure Act, have to take all those comments and do an economic analysis that takes into consideration the cost.
So in those comments, I mean, one of the things is suggested, I mean, this is despite, I think, about 1,000 companies have already voluntarily reported emissions from their customers and suppliers. We call it Scope 3 emissions, as you know, where most of the firm's greenhouse emissions can originate. So on top of that, we also are now seeing thousands of additional U.S. companies will soon be required to report Scope 3 emissions to comply with the EU standards. And then California, I think, just passed a bill that would require roughly 5,000 public and private companies to report Scope 3 emissions, correct?
Yes, I believe both Europe, and if the governor signs the law in California,
Sure.
that will be the case. And it will change the economics because it, in essence, changes the baseline.
So do you think you're going to look at that? And because those three, you know, just looking at those moves by California, of course, and the EU, Scope 3 emission disclosures, would it undermine, I think, the argument that such reporting would be overly burdensome to be required by SEC?
While it may change the economics over the course of the years, California's rule wouldn't be in place till 2027, I believe. It's still, we, the SEC, have to stay within our remit and the laws as Congress has passed. And it's about investor decisions and what they're being disclosed.
Sure. So if I may, Chair, I would like to submit for the record a letter signed by 25 of my colleagues, House and Senate, urging you, Chair Gensler, to finalize a robust climate disclosure rule that includes Scope 3 emissions.
Without objection.
You know, it's pretty simple why we need a robust disclosure rule, Chair. I mean, it's simple maybe for me. I know this is what you do every day, but I think the impact on the ground for my families is pretty clear. I mean, currently U.S. companies can and do obscure their exposure to climate risks, as you probably already know, and threaten the investments that retirees and workers depend on. So for example, like you look at Brookfield Renewable, an affiliate of a giant asset manager, and Brookfield describes itself as, this is quote, one of the world's largest publicly traded pure play renewable power platforms. Sounds like a choice that would avoid climate-related financial risks, right? Wrong. A recent report found that Brookfield Renewable is invested in a fund that holds fossil fuel infrastructure assets, including Alberta oil sands pipelines, which the firm does not disclose in its SEC filings. This is just one example among many, Chair, of financial greenwashing, which regularly involves omission of Scope 3 emissions. So again, I really think such practices jeopardize the hard-earned life savings of many of my residents and workers across our country, retirees that invested paycheck after paycheck, year after year, to secure their financial future. So just please know, and I want to be on record, that I really would urge you to move forward on having a robust disclosure firm. But with that, Mr. Chair, I would like to yield the rest of my time to Member Foster.
Thank you. I just have one quick question. I take it that you're familiar with this graphic from Bloomberg that shows you lagging significantly behind your three predecessors in terms of the number of rules you finalized in the first 2 years of your tenure?
I did read that in Bloomberg Law 2 weeks ago.
Okay, now when your Republican predecessor, Harvey Pitt, finalized 34 rules in his first 2 years and 4 months, I guess, was that preceded by the sort of detailed cost benefit of all the possible interplays between all of these rules that our Republican colleagues are asking for?
It included cost benefit, but we benefit from,
But the interplay between the 34 rules, which now is apparent.
oh, I thank you. As best I understand, they did it rule by rule individually.
Individually, yeah. And so when Mary Shapiro did 28, or under Trump, Jay Clayton did 25 rules in the first 2 years, was there any, comprehensive analysis of the interplay that's now being demanded?
Again, we're following.
Gentleman's time has expired.
guidance.
Thank you.
Gentleman yields. Gentleman from South Carolina, Mr. Timmons, is now recognized for 5 minutes.
Thank you, Mr. Chairman. Chair Gensler, thank you for being here today.
It's good to see you again.
Yes, sir. The SEC's onslaught of rulemaking, I think, is severely impeding U.S. markets in the name of protecting investors from themselves. Your regulatory approach is an insult to the intelligent Americans and their ability to make risk-based decisions when investing. Quite frankly, we've never seen market participation at the levels we see today. The current ecosystem represents a thriving financial sector where people, no matter their income levels, have access to investment opportunities previously unseen in human history. And this is why I struggle to rationalize why the SEC continues down this warpath of rushed and quickly written proposed rules. I could go down the list and probably name dozens of proposals that I think are too broad and they lack quantitative analysis or have reduced comment periods, but I'm just going to talk about a couple of them. So on December 14th of 2022, the SEC released 4 proposals that would overhaul the regulations governing equity markets. These proposals make sweeping changes to how national market system stock orders are priced, executed, and reported. This is despite the fact that there is no indication of a market failure that would warrant such a sweeping overhaul of the U.S. equity markets. Traditionally, regulatory agencies introduce new regulations in response to market failures or when directed by Congress. Regulators tailor solutions to address the specific problems identified. However, with these proposals, there's no clear need for change in the market, nor has Congress mandated such sweeping reforms. The SEC cites the October 2021 SEC staff report on meme stocks as a rationale for the proposed rulemaking. However, the report does not recommend any equity market structure reforms. To this point, you have repeated this buzz phrase, the playing field isn't level, but you haven't explained what that means or cited how it harms investors. Investors have the best user experience and the lowest costs in history. The industry says you're just picking favorites between exchanges versus wholesalers and that retail investors may not actually benefit from these proposals. So that was my long intro. How concerned should we be about the potential for increased costs to investors, especially in scenarios where retail brokers may need to reinstate commissions due to changes like the suggested increase in price improvement?
The proposals were put out to address individual problems, but they really are about driving greater competition and efficiency. Right now, our equity markets on any given day, depends on the stock, between 30 and 50% is not in the lit markets. It's being traded in what's called the dark markets. And so we're trying to bring more competition in that. One of the rules actually has a tremendous amount of support in the comment file from many market participants, is about lowering the minimum increment you can trade at, a penny down to a half a penny, for instance, and things like that. So we're looking at these comments and we're looking through to update our rules.
So currently, tens of thousands of Americans can trade for free and at their fingertips. Do you think that your proposal will result in the reintroduction of commissions?
Zero commission does not mean it's necessarily for free. There's a lot of things that are going on behind. When you send a market order, that's a very sweet order because most investors doing 100 shares are not going to invest another 100 shares or another 10,000 shares behind it.
It's going to result in increased fees for the people that currently have no fees. But
Actually, what our economic analysis shows that in each of these roles, it would benefit. We believe that the benefits are significant.
sorry, so you're saying that if this rule goes into effect, that the people that are currently trading for free will not have to pay commissions? Because I think they will have to, because that's how the market's going to inevitably function. You're not going to be able to continue providing free trades if this rule goes into effect.
Actually, again, there's separate rules, but the one I was talking about is in terms of lowering the minimum increment. There's a lot of support for the other rules as well, to say that brokers have to give their clients best execution seems pretty straightforward to many of us.
I just think that if we're going to try to provide inclusion and participation in the markets for all Americans, we need to do this with a scalpel and not a sledgehammer. And I think you've been taking a sledgehammer during your time at the SEC. With that, Mr. Chairman, I yield back. Thank you.
Chairman yields. Gentlewoman from Texas, Ms. Garcia, is now recognized for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Gensler, for joining us here today. And I always look forward to your visits, and I'm thankful that you're here, and we're still all here to finish to the end. I want to bring back the poster that was referenced by Mr. Foster. This comes from an article written by Bloomberg Law titled "Gensler Lags Predecessors in SEC Rulemaking as ESG Plans Linger." In fact, they say that you have the slowest pace in decades. We see under Bush, it was 34, under Obama, 28, under Trump, 25, but you've only had 22 rules for the same period of time in the first 2 years. So we've had a lot of talk from the other side of the aisle about all these rules that are too many rules too quickly. You're not listening. You're not doing enough investigations. But Bloomberg seems to think you're a slacker. Are you a slacker, Mr. Gensler?
I don't know. I leave that to others to comment on, but we do things thoughtfully. We do it by the book. We take the economic advice that we get, and Bloomberg Law has these numbers, so they speak for themselves. I think Chair Clayton, under President Trump, did 64 final rules by the time he finished his 4 years. So our rule agenda
So
is.
you're not
about
even at
50.
half of what the Trump administration did.
Well, the chart says we've done 22. We're now at 24, and he had done 25, I gather. We just do it thoughtfully. We do it under the law, under the economics, and I'll leave it to others to comment. But we're doing it on behalf of the American public and for investors and issuers, and making sure that they don't work for the markets. The market should work for them. And all too often in this country, it seems to get turned around that somehow investors and issuers are there so that some market intermediary makes a
So
profit.
it's all about transparency. And could you just, in a few words, explain to the average viewer who may be watching today why transparency is so important in this area, particularly in this area?
Transparency helps foster competition in markets. When you have transparent pricing of products, or if you know that a performance of an investment advisor is more transparent, it tends to lower the cost in the middle, and that again helps you, average working or retired American, to invest, but it also helps the people with good ideas. If you lower the cost in the middle, and that tends to come from transparency, just as like when you're buying an automobile, it's good to know the transparency of what a few different auto dealers are charging for that same automobile.
Okay. Well, the other issue that you and I have discussed many times is how important financial literacy and education is in this sector. And the last time you were here, I told you of my concern about financial literacy, not only in my district and in Texas. The Federal Reserve Bank of Dallas reports that 8% of Texans do not have a bank account, and 37% of Texans have not planned for retirement. Financial literacy, of course, is key. Chair Gensler, could you provide an update on the SEC's educational efforts to improve financial literacy, not only in Texas, but across the nation, to improve people's understanding of the work that your agency does?
Ain't doing a
We
goddamn.
have an Office of Investor Education. It's a very important office. We also put out investor alerts often on our website, and we try to engage with the public, the broad investing public, to help them understand the markets, but also to protect themselves against wrongdoers in the markets. And if you have something to tell us, to also tell us through the tips, complaints, and referral.
Right. I also have a follow-up question on the financial inclusion regarding literacy, not literacy, but language barriers. What are we doing to address any language barriers in behalf of members of our communities and our constituents in terms of investors?
A very important issue. We've certainly done some things recently with regard to shareholder reports, but I think I'd want to come back to you because it's an important issue about language.
Well, thank you. And Mr. Chairman, I also would like to offer for the record the article that I referenced earlier.
That's available to members under general leave and without objections. So ordered. We'll now recognize the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
Thank you, Mr. Chairman. Chairman Gensler, good to see you.
Good to see you, Mr. Muser.
Thank you. So the SEC's climate rules, Scope 3, provision mandates reporting on emissions from activities not directly controlled by a company up and down its supply chain, as you well know. So supply chains, let's say from China or some other offshore source, for example, which are perhaps less scrutinized and submit data which could be suspect, as opposed to from a U.S. Resource, is an example of how Scope 3 data could be flawed and the system as a whole. So what are your thoughts on that? And is this, is this somewhat of a push towards capital towards certain industries as opposed to something else? I mean, what's the intent? And the other thing I'd like to ask you is, are you fully aware of how it's rattling many companies, right? I mean, this rule won't go into effect perhaps until next year. Companies are preparing for it, and as are private companies. Private companies are preparing for it, and so there's a lot of additional compliance that goes along with it. So maybe you could comment on that.
Two very good questions. First, on many investors are looking at what is the risk of companies with potential climate change. And one of the measures of that risk is the greenhouse gas emissions of the company and possibly their supply chain or so-called value chain. Though many companies know their own greenhouse gas emissions, they don't necessarily know, as you rightly pointed out, their entire supply chain. And fewer public companies are currently publishing that. We put out a proposal to bring consistency to the disclosure, but we heard a lot of comments coming in to say Scope 3 disclosure is not as well developed. It's not as many companies putting out. It's frankly not yet as reliable. And so we're taking that into consideration. And I'd say another thing is some people have raised from the Farm Belt, for instance, agricultural interest. We don't want to have to do this. We're small family farmers. We don't need to do this. And we, the SEC, don't regulate those private companies, those non-public companies.
Mm-hmm.
And so staff is looking very closely to ensure that we stay within our authorities, and it's about the public companies. On your second question about cost, we take that very thoughtfully into consideration, and we got a lot of comments. I know I was chatting with the member across the aisle about this, and
Can you give us the
we need to
analysis
take that
on some
into
of those
consideration.
costs? That was a follow-up question. Can you give us the analysis on the costs that you're taking into consideration? Have you run the numbers and
We're in essence adjusting our economic analysis. It's because we got so much feedback from the public on that.
Okay.
Particularly important point.
On the safeguarding rule as well, are you mentioned you were on and off. Director Bertzissel mentioned that he talks extensively with banking regulators. There are many regulators, however, that feel, and this is regarding the safeguarding rule, that if you talked more often with them, this rule would be written differently. What's your reaction to that?
Well, we have good ongoing discussions with our colleagues at the bank regulators. We continue to engage on this role and on other roles, and of course on market oversight. The safeguarding role is one where we've heard a lot from not only the investment advisors that it applies to, but from the banks that act as qualified custodians.
Okay, thanks. I'm changing gears a little bit here. There was a recent shareholder vote to extend the deadline for the DWAC TMTG merger. Demonstrated that nearly 400,000 investors want this merger to happen. Can you give me your assurance or feedback that a revised S4 handled in regular order will be expedited, whether for this merger or any?
Again, as you're aware, that's a company that recently settled an enforcement action because it had initially had a material misrepresentation of when it went public in its S1. I don't think they've filed an S4 with us yet, but when they would, that our Division of Corporation Finance would handle it in regular order.
I appreciate that very much. I yield back, Mr.
Gentleman
Chairman.
from North Carolina, Mr. Nickel is recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Gensler, thanks for being here. I want to start by applauding the important work of the SEC and the public servants who work under you. I think it's a lot to be proud of, but a lot of the decisions you've made, I frankly have been scratching my head to try to understand your thought process and what goes into the decisions that you make. And so I tried to figure out, how can I understand Chairman Gensler a little bit more? And I read and saw that you are a marathoner and an ultra marathoner. Is that right?
Well, in my day, yes, I did do the John F. Kennedy 50 miler.
I looked and found that less than 1/4% of the world's population has done a marathon. I did the New York Marathon, so have at least accomplished one. My first question just is, after being here now for over 3 hours, being on, testifying before Congress in a hearing like this probably isn't one of the things on your schedule that you're super excited about. But how would you rate testifying in Congress and a marathon? Which is easier?
I love being in front of this committee. I've been here probably 20 times in my life. This is a great room and a great committee. Marathons are a little harder.
Thanks. All right, so I want to get into securitization.
If the gentleman was suspended,
I
we asked the
yield
witness
to
to
our
answer the
chairman.
question. We asked the witness to answer the question.
Oh, wait, I think that this is easier than
Sorry.
running the New York City Marathon.
Okay.
Thank you. So, all right, securitization. It's a cornerstone of affordable access to credit for families and businesses in my district, represent North Carolina's 13th district. For example, securitization fund around 70% of residential mortgage loans every year and provide funding for auto loans and credit cards. I'm concerned that your rule proposal on conflicts of interest will impair the ability of securitization markets to function by outlawing activities that have no connection with securitization transaction and reducing participation in those markets. This would increase the cost and reduce the availability of consumer, mortgage, and business credit for my constituents, which is a real problem. And frankly, we have an economy that doesn't work for everyone, and it is so hard for so many of the constituents I represent to get credit and to get a loan and to do those things. The SEC said it was, quote, unable to reliably quantify many of the economic effects, end quote, of the proposed rule. Given these uncertainties, and to avoid compounding the credit crunch that's already, again, hitting my constituents incredibly hard, will you commit to reproposing a rule that is more tailored to the feedback the SEC has received from the public?
So one, the capital markets are really important for credit cards, auto loans, mortgages through this securitization market. Two, Congress mandated that we actually do a rule to address potential conflicts that sponsors of those asset securitizations might have if they're on the other side taking positions in conflict with the investors. That's what we're doing. We got a robust, good comment file on that. We're looking at that closely. I can't prejudge it, but I think that the comments that we received, we can hopefully sort through.
Thanks. And I'd certainly urge you to repropose the rule as it threatens to disrupt the housing market in North Carolina and across the country. I want to move on to our grayscale letter. I sent a letter to you yesterday along with my colleagues, Congressman Flood, Torres, and Emmer, urging you to approve the listing of spot Bitcoin ETPs after your recent loss in court to Grayscale. Now that the SEC has the court's decision in hand, rejecting your rationale for denial, does the SEC plan to approve the current pending spot Bitcoin ETF applications?
Thank you for your letter. I did read it last night. Again, we're still taking this under advisement. It's a recent court action, and staff and commissioners will take it up as appropriate.
The court concluded that the SEC's denial of Grayscale lacked, quote, a coherent explanation, and then, quote unquote, falls short of the standard for reasoned decision-making, and then was, quote unquote, arbitrary and capricious. How do you explain the SEC's actions there?
We do that which we do under the law as best we can. Sometimes things go into court. We're still considering that court decision. I think it was a district court. I'm sorry, it was appellate court. It was appellate court, but we're still considering that appellate court decision. And I don't want to get ahead of the staff or my fellow commissioners.
Thanks so much. And I will note that at 3 hours, this is far below my marathon time. Not even close, but I yield back.
Gentleman yields back. We'll now recognize the gentleman from Wisconsin, Mr. Fitzgerald.
Chairman Gensler, thanks for being here. Congressman Lucas and Posey talked about this earlier. I'm just going to bring it up again. It deals with the proposals regarding predictive data analytics. Just could you distill down again? How do you think the proposal is? Is there a lack of economic analysis, and is that consistent kind of with SEC's mission to protect investors? How do you see those two kind of meshing?
So good questions. One, there's a robust economic analysis, but we're going to benefit from public feedback on it. But two, the rationale. On the rationale, it comes to a really key thing. An investment advisor, whether it's through a robo-advisor or a broker-dealer, that they continue to put our interest, the investing public's interest, first when they're engaging with us, what's called investor interaction. They're not putting their interest in front of ours. So they can use data analytics and use math to put their interest ahead of ours, and that's not good for the investing public.
Are you afraid it'll be applied too directly on just about everything out there? From I mean, it could go down to the level of Excel spreadsheets. I mean, somehow it has to be applied. Right?
Here's the sort of balancing act. We're technology neutral. So whether you use, as you say, an Excel spreadsheet or you use machine learning, sort of the core question is, are you engaging with the investors and pushing them for your profits, not your personal profits, but the investment advisors' profits, right, or the investors? But we've got a lot of comments. The comment file is open until I think October 10th. So we're still hearing from the public, and this hearing today is a very important part of that.
A couple of times you've said the SEC's rulemaking, you're just kind of simply doing what Congress has asked for. Do you think that's consistent? I mean, there's 40 some rule proposals, and I don't know that Congress had asked for all of those. So how are you measuring that right now?
No, you raise a good point. It's not that you asked for it last week or last month, but our laws embodied by Congress are on the books, and we need, I think, really to stay competitive in the world, to update our rule books to make sure that the markets, the Wall Street broker dealers, the exchanges, the investment advisors, that they're working on behalf of your constituents, the investors, and the people with good ideas who want to raise money. And it's trying to drive greater efficiency in the middle of that market. And sometimes the middle of the market doesn't love that, because greater efficiency might mean a little less economic rents, a little less profits in the middle.
Let me switch gears again. I think we're concerned about FSOC's recent proposal regarding the designation of the non-bank financial institutions as systematically important, particularly the elimination of a cost benefit analysis requirement. Given your kind of the position as FSOC member, why would the FSOC eliminate the requirement to do a cost benefit analysis when determining whether or not a non-bank financial institution should be designated as systematically important?
I thank you. I am a member of the Financial Stability Oversight Council, and what we put out to public comment, so I'm only one voting member, but what we put out to public comment was really just to ensure that we get back to the guidance that was out there in 2012. I was a proud member back then of that committee too, that council then. And so we've really gotten public feedback on whether to, in essence, could there be financial institutions that were so important to the system, systemically relevant, that they be designated so and then come under the Federal Reserve for oversight?
Very good. I'm going to squeeze in one more here. I'd like to reiterate, Congressman Lukenmeyer talked about it earlier about the proposed securitization conflicts rule. When you were here, I think it was in April, you mentioned that the proposed rule was new and you hadn't looked at the comment file. At home, Wisconsinites rely on, private mortgage insurance for access to affordability and sustainable homeownership. How can you differentiate between managing risk and betting on both sides of the transaction without capturing necessary business activity like this, I guess? Yeah, how's that going to work?
Congress gave us the challenge to do that, and that's why we put it out to public comment. But you're allowed to hedge, you're allowed to do other transactions, but not bet against the investors. And that's, we're still working through the comments to try to finalize. It's a mandate from Congress.
Gentleman's time has expired.
Yield back.
Now I'll go to the gentleman from Colorado, Ms. Pedersen, for 5 minutes.
Thank you, Mr. Chairman, and welcome back, Chairman Gensler. I can't believe it's already been 6 months. Time flies when you're having fun. Doesn't feel very fun this week, though. I just want to thank you for your time today and expertise. I know you've discussed this at length today, and it's been a big focus in all of the areas of the key functions that our agencies play in helping support and advocate for our constituents. And, Ranking Member Waters touched on the real harm that a government shutdown would do specifically to your agency. And should there be a government shutdown, only around 400 employees will be retained to maintain minimal functions, with nearly 4,200 employees being furloughed. The bare bones staff that will remain working during a shutdown cannot perform all the responsibilities adequately. And you've spent time discussing a number of the functions that the SEC will not be able to manage, like protecting Americans from fraud, allowing investors to access our capital markets, and conducting investor outreach and education, among other important roles of your agency. And it is deeply concerning for me with the long-term implications of the chaos and dysfunction here in Washington and the perception globally around what role the United States is going to play and if we are a market that people should continue to invest in and the real concerns out there. And so in your opinion, how do you think that the government shutdown will impact America's capital markets and the global standard that the global gold standard that we have always had?
The question is
In the short term, there's a risk that we, the government's important market regulator, don't have the resources to oversee the markets, whether it's a day, whether it's a month, whatever it is. In the longer term, it's just the confidence in our capital markets and our confidence in our system of fiscal deciding the fiscal choices that Congress and the administration does. And we see that those challenges in terms of investors around the globe. We're 40% of the world's capital markets. We're only 23% of the world's economy. So and that's a good thing. We're punching above our weight class, so to speak. That's a good thing. But the confidence in our system can be shaken as well.
And we saw that with the recent, not actually coming to an agreement and potentially going off a fiscal cliff. Even though that didn't happen, we know that we were downgraded with one bureau. There's going to be long-term economic consequences. But we know that there's billions of dollars of damage because for the first time, people are questioning whether or not the United States will pay their bills. And so these things, these political gains have long-term risks. So I want to spend the rest of my time. This is an area that I know you have a background in, and it's going to be absolutely essential that we're working in partnership to address the challenges the opportunities and challenges that AI poses for this country, and specifically for our financial system. And in the morning of May 22nd this year, an AI-generated image of an explosion near the Pentagon spread widely throughout social media. Immediately, the stock market dipped, and we saw a significant decline. We were able to recover when we were able to confirm that was in fact fake. But we know that these are challenges that we're going to have to address together. And Mr. Chair, I'd like to enter the Bloomberg News article, How Fake AI Photo of a Pentagon Blast Went Viral and Briefly Spooked Stocks, into the record.
Without objection.
And so AI has the potential to significantly impact our financial system and our capital markets and our banking system. And this needs to be addressed at every level on how we can mitigate against some of the negative consequences. I'm proud to be joining my colleague and friend in introducing a bill to examine how artificial intelligence will impact the financial sector and how we need to regulate this. So I want to hear from you, though, on what we can be doing, what you recommend that we do to address the challenges that AI poses in the future.
One is, I think it's great opportunities. It's probably going to drive productivity and so forth. But in the financial sector, I do think that there's risk of deep fakes. Look, fraud is fraud. Even if you're using artificial intelligence, there's usually some human behind it. But that's a real challenge to focus on.
It's all the stirs.
All right, I yield back. Thank you.
Gentlelady yields back. The gentlewoman from California, Mrs. Kim, is now recognized for 5 minutes.
Thank you, Chairman. And Chairman Gensler, thanks for being with us today. I'm concerned that the SEC, under your leadership, has not carefully considered the aggregate costs of and overlapping nature of your proposed rules and regulations. And as you heard, there is an erratic pace of your proposals. And I want to paraphrase your own words. These erratic pace of your proposals undermines the finest capital markets in the world. And each proposed rulemaking, now over 50 since the spring of 2021, will make it more costly for small businesses to raise capital in the markets and difficult for hardworking investors in my district to benefit from gains in the markets and save for retirement. And I remember when you came before our committee early this year, you said that the SEC's hardcore proposal would level the playing field for my constituents. But I completely disagree with that notion. And I urge you to please revisit the swing pricing and hardcore proposal. I know some of my colleagues across the aisle also raised this issue. So please tell me, how would the hard close proposal level the playing field for my constituents in Southern California when you're proposing a hard close at 4 p.m. in Eastern Time? It is 1 p.m. Pacific Time. So could you answer that?
So again, what we're trying to address is to ensure that when somebody redeems from a mutual fund, they don't leave everybody else in that mutual fund with losses or what's called dilution. I would say, given the clock right now, anybody in your district already has to put the redemption order in it at 1
All right.
o'clock. We're not,
Let
we're
me-
not changing that.
Let me reclaim, and I want to tell you that I'm specifically talking about my constituents being put at a competitive disadvantage compared to someone operating Eastern time. So you don't believe that a fund or an investor in California would be put at a disadvantage when they have to stop trading at 1 p.m. Pacific time, whether it's mutual funds or whatever that you're talking about?
I'm just observing currently, because the New York Stock Exchange and the stock exchange is closed by 4 East Coast time, and mutual funds redemptions are by 4 o'clock. That's currently, we're not changing that. That's already existing.
Again, 4 o'clock Eastern time is 1 p.m. Pacific time. So in my home state of California, obviously, we are very concerned about this, okay? Because we have to stop trading at 1 p.m. But let me move on. I know in my home state of California, Silicon Valley Bank failed largely because it wasn't hedging its interest rate risk. And you have proposed a rule on conflicts of interest for securitization that would make hedging this exact type of risk much more difficult. Surely this is not the intent of the statute or your proposal, but it is what the rule as written would do. And I heard your response, your engagement with, Congressman Fitzgerald, that hedging is mandated, but that is not what I'm hearing. So I would like to ask you if you can commit to working with me to ensure that the final rule clarifies that risk mitigating hedging is allowed, because the current rule is unclear on that point.
Again, I think it was Congress that has the risk mitigation hedging, but not trading against the investors. And so that's really the job of, we put it out to public comment. But you've raised an issue of just broad, general interest rate hedging.
Well, I'm talking about that hedging issue, which is very important. And with all due respect, I believe the lawyers outside of your office disagree. And I think the last thing we want is a chilling effect on hedging. And let me remind you, SVB is a glaring example of how to get things wrong. And I hope we can work together to ensure that the final rule leaves the important risk mitigation tools intact. I just want to talk about the 34 items on your proposed rules list for 2022. This is triple of that previous year. And in fact, over the past 2 decades, 2021 was the only time the commission proposed on more rules. So which obviously was mandated by Dodd-Frank Act. The October Inspector General report said that the staff believe that your more aggressive agenda potentially limits the time available for staff resources and analysis and increases the litigation risk. So can I just throw in the question, what sort of things increase litigation risk? Would you be able to respond to that?
Gentleman can answer for the record. Gentleman can answer in written form for the record.
Okay, thank you.
Ms. Presley of Massachusetts is recognized for 5 minutes.
Just a little shorter, baby.
Thank you, Chair Gensler, for joining us today. There are unrelenting people, institutions, forces at work that seek to dismantle gains that have been made in diversity and equity and inclusion, from corner offices, state legislatures, the Supreme Court, and my colleagues across the aisle. In fact, when they got the gavel, the very first thing that they did, one of their very first actions, was to dissolve the DEI committee under FSC that was stood up by Ranking Member Waters, chair at the time. And that committee was headed by Joyce Beatty. So the other side isn't taking any days off, so I'm not taking any days off either. And that's why I want to talk to you about diversity on corporate boards and understanding the importance of disclosure and transparency when it comes to gender, racial diversity, and other data, along with the ways in which that can impact financial performance. We all know that corporate boards are powerful. They play a critical role in determining the mission of a company, its values, its vision, its strategy, everything from who the company will hire to which stakeholders it listens to. Now, for decades, white men have made up the majority of corporate board members, and they still do. Across S&P 500 companies, nearly a third of board directors are women, despite women making up 50% of the country. Only 22% are people of color, despite people of color making up 41% of the country. These gender and racial disparities should not be ignored. The Securities and Exchange Commission plays a critical role in overseeing corporate governance, and that includes work related to diversity and transparency. Chair Gensler, research shows that diverse boards better reflect our country, and I want to underscore this, lead to improved financial results for companies. I could sit here and debate fairness and morality and right side of history all day, but as my good friends at Black Women on Boards so often say, this is not a matter of black or white. It is a matter of green. So this is about improved outcomes. So what is the SEC doing to increase disclosures on corporate board diversity and inclusion?
Not a darn thing.
Early in my time at the SEC, we had in front of us a filing from the stock exchange called NASDAQ. It's a self-regulatory organization that actually has a listing requirement of NASDAQ address these issues. Under the Exchange Act, under the laws, we approved that. That's still a matter of court challenge in the Fifth Circuit, if I recall. And I know that that's out there, but I think that
Let me
is an
reclaim my
important
time
piece.
because I'm running out of it here. That's right. The NASDAQ proposal was approved by SEIC, calls for 2 diverse board members based on gender, race, and LGBTQ status. So this information is important. You agree, yes or no?
Well, we approved it under the Exchange Act, under the guidance there. I have to be very careful about.
Okay, well, at the end of the day, this disclosure of this data is necessary because as we know, that which gets measured gets done. So we need that transparency. And I also think that the SEC needs to go much further and require greater disclosure of diversity, such as disability status, and greater disclosure of the company, including senior management and the workforce. So will the SEC commit to looking into expanding diversity and inclusion disclosures?
Staff has continued to work not only on this, but more broadly also in human capital
Yes or no, Chairman
disclosures.
Gensler, my time is running out. Can you make that commitment? This shouldn't be a hard commitment. Can you make that commitment to looking to expanding diversity and inclusion disclosures beyond just the NASDAQ proposal?
The staff staff of Corporation Finance continues to review alternatives there. And
Okay, all right. Thank you. Just a quick history lesson. The first Black woman on a corporate board was Patricia Robert Harris, and she was only appointed in 1971, roughly 50 years ago. The year is 2023, and it's well past time that we have corporate boards that reflect the true diversity of our country, not only from a place of justice and fairness, but for improved outcomes, improved financial outcomes. My colleagues across the aisle have already made it clear they don't care about diversity. Their first action when they took back the gavel of this committee was to scrap the Diversity and Inclusion Subcommittee established by Ranking Members Waters. They are on the wrong side of history when it comes to this issue and so many others. Chairman Gensler, it's important that the SEC be on the right side of history and press forward with corporate board diversity.
Gentleman from Nebraska, Mr. Flood, is recognized for 5 minutes.
Thank you, Mr. Chairman. Chair Gensler, I'd like to continue our discussion about SOB 121 staff bulletin from the SEC that would potentially have significant effects on the ability of banks to custody digital assets.
Hold on.
Let's briefly begin by following up on something that was raised the last time you were in front of this committee.
Digital asset questions.
You previously said that prior to the issuance of SOB 121, your staff did not confer with any of the prudential regulators. Is that correct?
You'd have the transcript, but I think that our staffs do talk to the prudential
Prior to the
regulators.
issuance of SOB 121, did your staff confer with any of the prudential regulators?
With regard to that particular
Correct.
staff bulletin, I don't recall that they did. I know that they have.
So let's let the record reflect that the SEC staff did not think to confer with prudential regulators before issuing the staff accounting bulletin. In response to my question, for the record from April on this topic, you stated, quote, SOB 121 provides non-binding staff guidance on the application of existing accounting and disclosure requirements under US GAAP. Prior to the issuance of SOB 121, Mr. Chair, did FOSB issue anything related to the custody of digital assets? And if so, what was issued?
I'd have to get back to you, but if you're asking about the Financial Accounting Standards Board, I don't know that they had done something on custody, but we could get back to you.
Since you cited the generally accepted accounting principles in your response, I decided I'd take a look at this myself. Prior to SOB 121's issuance, FOSB had not published anything related to the custody of digital assets. In fact, the board added accounting standards for digital assets to its agenda in May of 2022, 2 months after the issuance of SOB 121. Your response to my question, for the record, from April, also indicated that SOB 121 provides guidance on the application of existing accounting and disclosure requirements under the SEC rules. So here's a question. Prior to the issuance of SOB 121, what rules had the SEC finalized relating to the safeguarding of digital assets?
Well, we have on the books a rule from 2009 that applies to the custody of digital assets by investment advisors because it covers all funds and securities. That rule's on the books. We also had finalized something around special purpose broker dealers, which relates to crypto broker dealers.
So I took a look at this topic myself. The answer, quite frankly, is none. There were no SEC rules on the books that directly address the topic of custody of digital assets. As you know well, the SEC issued a proposed rulemaking on custody, including digital asset custody, in February of 2023. And that rule has not been finalized to this day. So to recap, the SEC failed to confer with prudential regulators despite the fact that anything changing rules around the custody of assets for banks, regardless of whether the bank is publicly traded, would be of obvious consequence to them. Then, when justifying the bulletin, the SEC cited the GAAP and SEC rulings. However, at the time when the bulletin was issued, there was no action by FOSB, no rulemaking from the SEC on this topic. In April, you said you wanted the SEC to, quote, stay in our lane, end quote, with regard to SOB 121's potential effects on a bank's balance sheet. It's fair to say that the fact pattern we have is that the SEC is not just going out of its lane, but it failed to comprehend the existence of any conflict with prudential rules. Additionally, the SEC's justification for issuing the bulletin is based on accounting guidelines that did not exist when the bulletin was issued and rulemaking that was not even started until nearly a year after the bulletin was issued. It's pretty obvious that one of two things happened, and both are bad. On one hand, it's possible that the SEC was well aware that there was no strong justification for issuing the bulletin and chose to do it anyway. That would show a pretty straightforward case of regulating by guidance and unsubstantiated theory. On the other hand, the SEC made some obvious basic mistakes in the issuance of this bulletin. In light of these mistakes, it's worth mentioning the SEC Inspector General's report on management and performance challenges. Among other things, the report indicated that very high attrition has required the SEC to rely on detailees with little or no experience to contribute to the core regulatory tasks such as rulemaking. The case of SOB 121 raises the question of whether the SEC is compromised. Thank you, Mr. Chairman. I yield back.
They're compromised.
Gentleman yields back. We'll now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Welcome, Mr. Chairman. I don't know if you need time to respond to that.
I would just say, Mr. Flood, if I can, because the other member allowed me to, the SAB 121 guidance is based on GAAP. GAAP already exists. It doesn't need a new FASB statement. And the custody rule at the SEC from 2009 already covers funds and securities to the extent it might be crypto securities. It already covered. It wouldn't have covered something like Bitcoin, the chair and I have talked about, that's not a security, but it would have covered crypto securities. Thank you.
Again, welcome, and thank you for your willingness to enforce the law where it applies. Appreciate that, especially in the crypto space. After many decisions in favor of the SEC's position, the SEC saw its first split decision, I would say, in the major crypto case in court with the July 13th ruling involving Ripple's XRP. In a partial victory, I guess, for Ripple, the Southern District of New York held that XRP was not a security when
Right.
sold on a public exchange,
Right.
but it is when sold to institutional investors, which
Right.
I found surprising and counterintuitive given the vulnerability of individual investors versus institutional investors, and also the asymmetry that invites into the legal analysis involving crypto. But the wider picture is that I worry
What you worried about, Mr.
that we're heading towards a pattern of court battles to
What you worried
determine
about, Mr. Nick?
if each individual token is either a security or not. And I just wanted to know what your thoughts were on that decision. I know it's far from over. This case is far from over, but I just wanted to express to the committee what your views are on that issue and on that decision, to the degree you may.
I appreciate the opportunity, Congressman, but as we, as a commission, actually have filings in front of that court on this matter right now, I think those filings speak for themselves, and I just don't want to in any way speak to something and say, even choosing a word differently than the commission voted to make filings in that following.
Okay.
In essence, we filed
I believe that.
what's called to potentially do an interlocutory appeal.
Okay, fair enough. I suspected as much. One of the major proposals in the recent digital assets market structure legislation involves allowing a crypto firm to provisionally register and to be held harmless for a post-registration period. By now, we're all well aware of the damage caused by FTX when its CEO, Sam Bankman-Fried, defrauded millions of customers. More recently, the SEC took action against Binance for potentially, I think, similar behavior from looks of things. The Binance complaint contains damaging allegations, including operating an unregistered securities exchange, broker, and clearing agency. Further, Mr. Zhao of Binance's operation, control of customer assets, permitted them to commingle, again, just like FTX, customer assets and divert customer assets as they pleased. There are some concerns about this bill that the digital asset market structure bill, that it opens up a vulnerability for consumers to be harmed. And I was wondering if you had a view on that, and is there any concern that we should have with the way the bill is currently structured?
So if I can speak about the field itself rather than speaking about the bill, but it's a common practice in the crypto field right now to commingle that which we don't allow commingled elsewhere. And commingling what you might think of as an exchange, like the New York Stock Exchange, with brokers, you can think of your own individual brokers, and maybe a hedge fund or even a high-frequency trading shop, and even a clearinghouse, and maybe even some bank-like functions. And it's a recipe that has not led to good results in the crypto field and a lot of investors being harmed. So if Congress did anything, it would be separating out those conflicts.
Thank you.
Time's expired.
My time has expired. I yield back,
From
Mr.
South
Chairman.
Carolina is recognized for Mr. Norman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Gensler, are you aware of Prometheum?
Oh,
Sorry, I
Are
didn't
you
hear the
aware of Prometheum company?
Prometheum.
a company. I have heard of that company. Yes, sir.
Well, they testified
created
before
that
us back on June 13th. The CEO and founder of Prometheum testified before us that, and he assured us that only 20% of the company is owned by China. Does that concern you at all? And I assume you know they're a broker dealer, special purpose broker dealer for digital asset securities.
Any registrant in our markets has to comply with our laws, and whether they're partially owned or wholly owned by China.
But I'm saying in your position, does that concern you? 20% owned by China and the information that could be easily transferred to China, which is an enemy of this country?
Oh, sorry. What's really important, regardless of whether it's China or any other country, that our capital markets, it's a privilege to be in our capital markets, and that those companies comply with our laws, whether it's the company you mentioned or any other company controlled or partially owned by Chinese entities.
May comply with the laws, but still the threat is there that information is being shared on investors. We sent a letter to you back September 25th, Senator Tuberville and I. You know how long it took us to get this reply?
I'm sorry, September 25th, yesterday? No, I'm sorry.
Of 23, yes. Yes, that's right. We sent it 10 weeks earlier. It took 10 weeks, is my point, to get this back. What we ask you to do is look into that, into the China connection, which is a serious concern, should be of yours and your role. Basically, and I'm not going to read it, this is just a non-response. I mean, it's just words. And if what's concerning to me is if somebody in your role is just shuffling paper, it's a danger to this country.
There are a number of broker-dealers in our country that have affiliation with China. You named one. It's not the only one. I think your letter and some other letters from the senator named some of the others. And those broker-dealers have to comply with our laws. They actually have to, under our laws, have their books and records here so they can be inspected and looked at by FINRA, which you mentioned.
Is China go by the rules? I mean, does communist China go by the rules?
They have a different set of laws there. They have a different government, but I'm saying if you're here in the U.S., they have to comply.
Here's what we would ask. I mean, 10 weeks to get this, to get this letter, was it 2 paragraphs, is really an insult. Are you familiar with metamaterials?
Yes, I am, sir. I'm not very deeply, but it is a company that I've heard of.
Do you know what the aggregate shares are, audited shares, count of MMTLP is as of close of market on December 8th, 22?
Oh, man.
I don't know. I know that it's a company that then exchanged into something called NextBridge, I believe.
Okay. Does SEC have this information on the audited shares?
It may be a matter of public record. I mean, it was a company that did an exchange and became another company.
We'll try writing you another letter, and if you would look into it, we would appreciate that.
Thank you.
You know, as been said earlier, the arbitrary rulemaking that is occurring under your rule on theoretical assumptions is really getting our constituents that are involved in the financial markets very upset. And considering you're going way past the boundaries that need to be going.
Duh.
And I think you've made SEC a crusader of rulemaking by enforcement rather than modernizing the regulatory guidance. This isn't something new that you've heard.
Tell them, man.
My only request is that,
Exactly what they're doing.
you know, you can blame it on staff turnover, you can blame it on a lot of things, but that you would prioritize this rulemaking and actually we'd make the case for reductions if you would even consider something. I yield back.
Gentleman's time's expired. Gentleman from Texas, Mr. Green is now recognized for 5 minutes.
Thank you, Mr. Chairman. I thank the ranking member as well. And of course, I'm grateful to the secretary for appearing today. Thank you very much. It's been an honor to work with you. Mr. Secretary,
I'm honored to have another title, but it's just Chair or Gary.
Chair, okay, all right.
I think he's setting them up for something. Set them
Mr.
up.
Chairman, excuse me.
Trying to, he getting the curve already, but it's really going to be a split.
Traditional services of an exchange, if you perform those, broker, clearing agency, these are the kinds of things that should be registered. Is that a fair statement?
Yes, if you're a broker in America, if you're a dealer in exchange, not only register,
in
but
and
then
register.
comply with the laws so that the public is protected.
Mm. And in your capacity as a chairman, if you are of the opinion that these things are not taking place, are you duty bound to do what is within your authority to protect the public?
Yes, and we end up being a cop on the beat, and it takes a 5-member commission, but
Cop on the
sometimes we
beat.
bring enforcement actions if people are not properly complying with the laws and registering.
Public Citizen has indicated that crypto amounts to a giant Ponzi scheme
With
whose
fraudsters and
victims
hucksters.
disproportionately include low and moderate income
Also
individuals
hucksters.
as well as people of color.
Tell him, I might. Tell Mr. Green. Get
I'm
him.
concerned about that. I appreciate your being the cop on the beat. I want to protect people from what may be a Ponzi scheme. There are different opinions about this, but what are some of the consequences of having a poorly regulated digital currency?
Well, the crypto token field has, there's been billions of dollars of losses. And in fact, there's some studies that
Fraudsters and
suggest that
hucksters. Look at it.
lower income communities and communities of color have lost more, and that it's not been to their advantage at
Watch
all
dual
to
economics.
be
Y'all
investing
ain't
in
gonna be
these
like that.
assets on average.
You watch dual economics, you're gonna be straight for the next
Um,
bull market.
Really, it's a matter of the American public can decide what investment risks they want to take, but they should have the full and truthful disclosure about those investments if they're under the securities laws. And then the trading platforms themselves should comply with the laws and not be entering into a bunch of conflicted services where they sometimes are trading against their customers on those exchanges.
Mhm. Do you consider the dollar, the American dollar, an effective, efficient digital currency?
Well, the American dollar, which is, the sort of the leading currency around the globe, most of it is digital. I mean, we buy a cup of coffee at Starbucks, or we get paid, or we pay our rent digitally. Occasionally, we still use paper or cash.
And do you believe that properly regulated, we can have digital currencies that won't amount to a Ponzi scheme?
Well, I think the US dollar is quite strong. And I think the US dollar, because we use it digitally already, is a form of a digital dollar. Crypto tokens are really quite something different, sir.
Tell us
They're
what
not
they
a
are, Gary.
currency. They don't, I mean, this is going back into economic history, but they don't fulfill the 3 functions of a currency, of a store of value, a unit of account,
real.
medium of exchange. They might maybe in another day, but not in 2023, frankly.
And
Yeah, I heard that.
our failure to act, or your failure, because you're really the person who's in the hot seat, as it were. Our failure to act can cause a lot of harm to a lot of people, as we have seen with one circumstance. And I thank you for what you're doing to prevent that harm. I really do. Thank you.
Thank you.
Go back.
Gentleman from Wisconsin, Mr. Stiles, recognized for 5 minutes.
Thank you very much, Mr. Chairman. Thank you, Chairman Gensler, for being here with us today. This summer, I asked Director Girding about the SEC staff, about whether or not the SEC staff conducted legal analysis of shareholder proposals. And Director Girding seemed to have a tough time answering the question. And I walked away understanding that the SEC does not conduct much, if any, legal analysis of a shareholder proposal. It's troubling to me because I think that would be one of the roles of the SEC, in particular, following the SEC's review of the particular Traveler shareholder proposal, the racial equity audit, that I think could have driven that company to be forced to engage in illegal behavior. And so asking you if you could give me a clear answer, does the SEC conduct legal analysis of shareholder proposals?
In preparation for the hearing, I watched your testimony between
just say yes or no,
Director
dog.
Girding and you.
Goodness.
I think it is part, and I don't do this on a day-to-day basis, but I think when staff looks at, sometimes companies come in and ask the staff's opinion on things. Staff does look at, one of the components they look at is the legal.
So not
parts
every
of it.
time. So when you say sometime, I think it's just important for us to understand whether or not we should make that explicit. I think it should be explicit. So sometimes the SEC looks at whether or not shareholder proposal is legal, and sometimes they do not review whether or not shareholder proposal is legal.
As I understand it, I believe it's one of the components of the review, but I'd be glad to have staff work with your staff and get you the details of the.
I'd like you to, I mean, and the fact that you reviewed it in advance of this committee hearing, which I appreciate the amount of time and effort you put into preparing for a hearing, but you don't have an answer specifically whether or not the SEC conducts a legal review, not even a legal opinion, but just a legal review on each shareholder proposal, to me, would be a baseline review for the SEC to
I'm here
conduct.
saying I believe that it's part of the review, but I don't know if it's on every shareholder proposal because it depends on the nature of the shareholder proposal, of course.
Okay. I'd like you to come back with that information about the process in which you review shareholder proposals in light of probably two key things. One is we brought in the two largest proxy advisors, ISS and Glass Lewis, and they specifically said on the record that they do not conduct a review for legality. They instead rely upon the SEC's analysis for legality. On the record in this committee room, your director and now you kind of go back and forth as to how you conduct that legal review. I think it's really important for us as policymakers to understand whether or not anyone, the SEC or proxy advisors, which may not be under, we can get to how they're registered with the SEC, but who's conducting the legal review because it has a significant impact on companies. And if we build upon that and we look at the staff legal bulletin 14L, we've seen a dramatic increase in the number of shareholder proposals. We're seeing more focused on social and political concerns. And I go back and look at the underlying language of that legal staff bulletin saying that they would consider whether or not a proposal concerns a matter of widespread public debate. Can you define widespread public debate?
I think, sir, that it's really, and this goes back all the way back to the 1960s of shareholder proposals, that investors can make shareholder proposals on the term you used on wide scale.
Widespread public debate is your legal staff bulletin.
And that goes back many decades.
But can you define it? I understand there's a history to it. I understand, but legal staff bulletin came out under your chairmanship. Can you define the term widespread public debate?
And the staff does, when asked, give their informal advice, but ultimately it's between the company and the investors.
Understood, but don't you think that's of concern that you can't define what widespread public debate is when your staff bulletin says that that's a point of review for shareholder proposals? I'll offer you that it concerns me, in particular in light of the dramatic increase in the number of shareholder proposals we've seen that are based on social and political objectives rather than governance of the nation's largest companies. See if I can get this in really briefly. We've discussed your use of email. You've had an aggressive enforcement campaign on off-channel communications for financial firms. Have you used anything other than official SEC resources to conduct your government business?
Dang.
No, I comply with the laws, but I also, if somebody sends me an email, then I forward it into the SEC.
Thank you very much for your time. I yield back.
Gentleman from New York, Mr. Garbarino is recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Gensler, thanks for coming today. Financial services sector and the Biden administration have made harmonization of cyber incident reporting a top priority. In fact, the Department of Homeland Security Cyber Incident Reporting Council's recently recommended the federal government coordinate among themselves to reduce the burden on the reporting entity. But instead of reducing the burden, the SEC has finalized rules that CERC has called duplicative cross-sector reporting requirements and that overlap with congressionally mandated Cyber Incident Reporting for Critical Infrastructure Act, the CERCIA. Given the council's designation, why didn't the SEC harmonize its cybersecurity disclosure requirements with existing regulations, and more importantly, wait until the Department of Homeland Security and CISAs developed the rulemaking under the recent signed into law CERCIA?
One, we've had good discussions with the Department of Homeland Security, but we finalized the corporate disclosure piece because it was important for the public investors to know if there had been a material cyber breach.
Is it more important? Is investor information more important than Homeland Security? Well, and I asked that question because the reason we want to harmonize, and the reason we as a Congress have said harmonize, and the reason the Biden administration has said harmonize these incident reporting rules, is because we've heard from the private sector that their cyber employees are spending 40 to 50% of their time, and we've spoken about this before, on complying with cyber regulations, not just yours, but with all sorts of different cyber regulations. So and we talked about this last time we were here, specifically the rule that was just finalized in July, and you said at that time, you've been having good discussions with DHS. But again, this rule came out and and DHS said, I quote, that this current rule is duplicative cross-sector reporting. It's a duplicative cross-sector reporting requirement. So even though you've had good conversations, I guess they didn't lead anywhere because you still came out with the rule.
Actually, they did, because it's only reporting to the public if it's a material cyber event. It's 4 business days, which actually is longer than the CERCIA 72 hours. And thirdly, as important considerations in there that if the Department of Justice thinks for national security or public safety, it should be delayed, it will be delayed.
It is longer. 4 days is longer, but within a material breach, there's different requirements there. So I have to ask, because there's also a concern that you have companies that are reporting a possible material cybersecurity breach that might not have been able to fix that breach. And if they're publicly reporting it, it could, one, put that company at further risk, or two, put other companies who are using the same system and the same backdoor can be found in their system. We just saw over the summer a company, there was an attack on a company. They announced this attack before the patch was released, and you saw other companies and 3 federal agencies get hacked under the same vulnerability. So I'm concerned that having this public reporting before the breach is fixed, before the patch is fixed, is going to cause more harm than good. And I'm not saying don't regulate cybersecurity. I think it's very important. I just think when our goal is harmonization, when the Biden administration's goal is harmonization, when everybody is saying harmonization, having these rules come out that are just going to be duplicative and cause more harm on the companies that are supposed to be protecting information is not a great idea. I'm running out of time, so I do want to move on to something else. Between 2019 and 2022, the annual cost of operating a consolidated audit trail, or CAT, increased by 900%. In March, CAT unveiled a 2023 budget exceeding $223 million, which is 10% of the SEC's entire budget. The SEC recently approved a funding model that would pass nearly all these costs on to market participants. What is the SEC doing to control the costs of CAT? I understand SROs control and operate them, or owned and operated, but it's under your umbrella. I need to know what you're doing to control those costs and if you would
What are you
support
doing,
moving
Gary?
CAT onto the SEC's
What are you
budget.
doing, Gary?
I don't know, Mr. Chair, what you're going to tell me.
If the gentleman would respond in written form to the gentleman's question. And I appreciate the gentleman's
Thank you.
leadership in cybersecurity issues, WIGWIM protocols, and the work he's put in
WIMWIG,
over the
yes.
years on those policies. He's worked in other committees. So
And WIMWIG is very important.
we'll now recognize the gentleman from New York, Mr. Lawler, for 5 minutes.
Thank you, Mr. Chairman. Chair Gensler, you have embarked on a rapid and extensive campaign to reform every facet of our markets. It is evident that your rules will significantly change our markets. For example, your equity market structure rules will impact all retail investors, encompassing over 228 million retail accounts. The swing pricing rule will have implications for every mutual fund involving over 100 million American investors. The climate rule imposes new costs on every public company. The predictive analytics rule will encompass virtually every type of technology. The private funds rule fundamentally reshapes the regulation of private institutions in a potentially unlawful manner. The pace and scope of your rules is unprecedented. Have you taken the time to do a comprehensive economic analysis examining the cumulative impacts of all of these rulemakings on the markets and broader economy?
Good question.
Representative Lawler, actually, our pace is about the same as prior administrations, and per
That's not,
Bloomberg law.
respectfully, we can disagree with that, and that's not what I asked you. I asked you a very specific question. Have you taken the time to do a comprehensive economic analysis, examine the cumulative impact of all of these rulemakings on the markets and the broader economy? Yes or no?
On each of the rules, we do a robust economic analysis, and then if another rule is finalized, we incorporate that, and we take into consideration that interaction in the possible further rulemaking and adjust the economic baselines.
So you are saying, for the record, that you have taken the time to do comprehensive economic analysis, examine the cumulative impact of all of these rulemakings on the market and the broader economy, yes or no?
For the record, what we do is we take into consideration as and if a rule is finalized, the interaction with other rules.
Right.
Because it changes what's called the economic baseline.
Yes. So have you done the cumulative impact? Have you studied that? Have you done an economic analysis on all of it?
We do them rule by rule individually.
Yep.
And also the interaction as it relates to other rules. If we were to finalize a rule, then we take that in consideration.
So can you explain your engagement with market participants before putting out significant rule proposals? Are you holding public roundtables?
We meet with the public extensively before the equity market rules. We had numerous meetings from when I came on in the summer of 2021 all the way through December of 22.
Chair Gensler, California Governor Newsom recently confirmed his intention to sign 2 bills mandating climate disclosure into law. You mentioned to the press last week that the SEC staff is, quote, going to take a look if it were to become law because it may change some of the economic baseline for our rule, end quote. It's evident that the law will indeed alter the economics of your rule. So can you make a commitment to allowing the public an opportunity to provide feedback on the commission's updated economic analysis before finalizing the rule?
We take in consideration public comment. We've had 16,000 comments, a lot of comments on the economics, and we often will adopt based on those comments.
No. What I'm asking you is, based on the reevaluation, based on the potential change in law, will you commit to allowing the public an opportunity to provide feedback on the commission's updated economic analysis before finalizing the rule?
I would say this, we're compelled, this is an important thing. California.
It's a pretty straightforward question. Will you allow the public to comment on the updated economic analysis before finalizing the rule? Yes or no?
We would put it, if we finalize a rule, it would be part of that finalized rule.
Okay. I know you like to obfuscate, but I'm honestly
No, I think,
asking you a
sir,
very
sir,
straightforward
I
question.
understand.
Can
where you're-
you
Where
commit?
you're headed.
Can
No,
you commit?
No, the
So
answer
you
is
won't
no.
commit. Thank you. At least you answered the
Hmm.
question. Thank you.
That's the first.
I want to touch on another factor here. The SEC recently proposed amendments to expand and update regulation systems compliance and integrity. The proposal would expand the scope of SCI entities to include certain registered broker-dealers for the first time. Feedback from market participants on this proposal suggests that the actual costs for this proposal are in the billions of dollars as a result of the SEC attempting to micromanage the technology setup of individual firms. Yet these enormous compliance costs are conveniently absent from the SEC's cost-benefit analysis. Why did the commission fail to acknowledge these costs in its economic analysis?
Gentleman's time has expired. If the chair will respond in written form.
Thank you.
We'll now go to the gentleman from Iowa, Mr. Nunn, for 5 minutes.
Thank you, Mr. Chair. Chairman Gensler, thank you and welcome back to this committee. I know each time we get to have a lot of questions on this. Last time we spoke, I addressed swing pricing and hard close proposals with you. I also want to reemphasize here the devastating impact that's had on many of my hardworking constituents, from their retirement plans, their 401ks, my nurses with 457 plans, my teachers with 403B plans. I think you get the gist of where we're going with this.
Yeah.
As you were well aware, after this morning's rule, I believe it needs to be withdrawn, and I look forward to your team's response to both Chairwoman Wagner and Ranking Member Sherman on the letter that we signed on to and are still waiting to hear back on. Look, I want to talk specifically here about the ag and small business communities that I represent. The extra regulations that the SEC is potentially proposing in this regulation under the guise of consumer protection, it's going to add $6 billion in increased annualized costs to the industry, an additional 6 million compliance hours, many of these being small family farms and medium Main Street businesses. I hope you appreciate this has a tremendous impact on my constituents back home. Along with 4 other members of the Ag Committee on which I serve, we have signed a letter here moving forward a conversation, which brings me to my question on the February 15th proposal rulemaking on safeguarding client assets aimed at reshaping custody assets. As you know, we have worked hard in your former role with CFTC on how this can be successful. But dozens of trade groups have signed up and identified that this rulemaking would represent trillions of dollars of assets that our constituents back home face. Both of these letters, Mr. Chair, highlight significant errors with the proposed rulemaking, and I'm going to begin this conversation by asking you consider withdrawing it until these things get fixed. Your definitions of custody and asset would expand so greatly they would encompass derivatives and future markets that have been overseen by the CFTC, your former organization, for decades. So with these bipartisan letters specifically, I believe that they would upend our markets overseen by the CFTC, eroding their essential risk management functions and putting our nation's farmers and producers at risk. Now, Chairman Gensler, in your 432-page proposal on economic analysis, do you know how many times agriculture was mentioned as part of this review?
I don't recall, but I suspect you're going to let me know.
Would it surprise you to know not once? In fact, it was only mentioned as a subcategory within a footnote. Clearly, this is concerning, particularly for my farming constituents, but for entire economies built around this, something the CFTC has been doing for decades. So, Chair Gensler, earlier you answered Representative Lucas' question. Has there been any coordination with the SEC and the CFTC on this issue?
Yes, we've been in dialogue both prior to the proposal and subsequent to the proposal, and I think that.
Can I get some specifics on that? When did you send a request over to the CFTC for this coordination? The day of before the proposal? A week before the proposal? After the proposal was already out?
Representative, it usually just is staff-to-staff dialogue, so.
Great. I look forward for your staff providing me the date in which you actually asked for this information from the CFTC. Did the CFTC provide you with any recommendations on your rulemaking?
We engage with multiple federal regulators on this role, and we'll continue to do that because we benefit
very happy
from
to hear that,
feedback.
Mr. Chair. I'd like to see that being transparently provided to this committee then. Did you read these comments and were they incorporated into your final proposal?
Sir, we haven't finalized a proposal yet.
Did you incorporate any of CFTC's
We haven't finalized an
recommendations?
adoption yet.
Mr. Chair, did you incorporate any of the CFTC's proposals into your recommendation?
We have put out to public comment to get feedback, and we get feedback, and it's benefiting this. And I think that we can,
So I haven't heard anything about the CFTC on this. You're putting it out to the public, which brings me to my next question. It's my understanding that you recently reopened the comment period without re-proposing the rule. Specifically, what value does this add to the ag community and my constituents for their grave concerns if you're reopening it, but you're not listening to the CFTC, the ag committees, or even what's happening in a bipartisan level within this committee?
we benefit by reopening. I think we reopened this because we had another rule that may intersect with this, the discussion we've had a lot here today. And so we reopened it formally to get further comment.
It might suggest to some that you didn't get the answers you wanted, and so you reopened it to others. So let me end with this. I urge you to withdraw this rule as my bipartisan and bicameral elements have argued the same. Thank you, Mr. Chair. I yield the remainder of my time.
Thank you. Good to be with you.
Gentleman from Florida, Mr. Donalds, is now recognized for 5 minutes.
Thank you, Mr. Chair. Chairman Gensler, welcome back. Hey, do you remember where we left off, you and I?
I do. You're a very good questioner, sir.
All right, well, let me
Remember it.
refresh. Let's bring some things up. Where we left off was, did you facilitate the payment for the Steele dossier for the Hillary Clinton campaign back in 2016? Because you were the CFO. You acknowledged that. You also said, in response to my question, that this payment was not something that I was aware of, quote unquote. Those are your words. Interesting things have occurred since then. John Podesta actually testified to a committee of Congress, and John Podesta testified to a question about, was Gary, meaning you, was he day-to-day, hands-on, signing every check? And so John Podesta testifies, actually he was under a deposition with a committee here in Congress. He says, yes, I don't know if he signed the checks, but he was there every day, meaning you. So let's circle back. Were you aware of the fact that the Hillary Clinton campaign actually paid for the Steele dossier, which unleashed one of the worst issues of intelligence malfeasance that our nation has ever seen?
No, sir, I answered this 6 months ago, and this is the same answer today. No.
You weren't aware of what was going on. Mr. Gensler, I find that very interesting because, you know, if I listen to some of the people and the staff that have left the SEC, you're very aware of everything that is going on. It's actually your MO. You're very hands-on. So you're going to tell the committee right now, you had no idea that the Hillary Clinton campaign, of which you were the CFO on, sent money to Perkins Coie for a dossier that was phony, that led to the spying on of a presidential campaign in 2016. You were not aware of any of this.
Sir, as a chief financial officer in a political campaign, I was not aware of what a law firm was doing with some of the monies that they got.
Now, I find that interesting because in some of your other rhetoric about CFOs in the public sector, the private sector of our economy, you are very tough on CFOs. You've said on the record on many occasions that CFOs have a fiduciary responsibility to the organizations that they cover, that they should be aware of everything that is going on. So how is that a standard you hold CFOs in the private sector to, but you don't hold yourself to that same standard?
That's not a standard that the SEC holds CFOs to. It's about their financials and that the financials are put together in accordance with GAAP and that the numbers are accurate. And that they're.
So did you accurately pay for the
material
Steele
regards.
dossier out of the Hillary Clinton campaign?
Sir, I learned about that way after President Trump was a president and Hillary Clinton was a private citizen.
All right, well, let's move on. We'll probably circle on that another time. I want to reference a story in Capital Account from June 13. Mr. Chairman, I ask for unanimous consent for the story be entered into the record.
Without objection.
The story notes that you met with Senator Tammy Baldwin in May about the SEC's proposal related to the 13D beneficial ownership disclosure, at which time you allegedly asked Senator Baldwin's staff, allegedly, to contact an organization called We the Investors to submit comment letters in favor of the 13D proposal. Subsequently, the SEC was flooded with 350 plus comment letters from so-called individuals, but mostly form letters stamped with the moniker We the Investors in favor of their proposal. It appears to me that you have engaged in astroturfing to advance your own agenda. Is this true? If this is true, is this a serious breach of impartiality, that would violate the spirit, if not the letter of the law of the APA?
Sir, again, I don't know what the press is talking about. I remember a meeting with the senator. It was a good thought.
Did you meet with Senator Baldwin in May with respect to 13D?
I think that it's on my public calendar that I met with Senator Baldwin. I meet with senators and representatives. on a
Okay, so here's what
regular
I need to
basis.
get from your public calendar if you actually met with Senator Baldwin. I think the committee would like to know that. In this meeting with Senator
think I
Baldwin's
did.
staff, did you speak to an organization called We the Investors?
I have no memory of that.
Mr. Gensler, the no memory routine from a lot of appointees is really getting old. You guys are discussing and leading some of the various regulations facing our economy. So to come before a committee of Congress, have no idea what you talked to with a senator's staff about 13D?
The meeting was with the senator, sir.
All right, well then, if you don't remember, if you don't recall what you said to a United States senator about key issues facing our
Sir,
economy
no,
from a
I'm-
regulatory basis,
Please, sir.
that's a real problem,
You're a
don't you
good
think?
questioner, but please, sir, that story is not one that I would confirm. It's not a story that I believe is accurate.
Let me ask you a question, broad base. Do you think it's appropriate for the chairman of the SEC, or frankly, the head of any agency, to engage with outside groups to accomplish the agenda they want to see through rulemaking?
We are responsible under the Administrative Procedure Act to hear from outside parties, market participants, constituents in your district, members
No,
of
that's not my
Congress.
question. We
We're-
want to
we're
hear from outside
obligated.
groups.
We're
Is it
obligated.
okay to foment outside groups to
Gentleman's
help you
time's
accomplish what you want to
expired.
see?
Gentleman's time's expired.
Thank you, Mr. Chair.
Generally from Indiana, Ms. Houshin is recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Waters, and thank you to Chairman Gensler for speaking with us today. Chair Gensler, under the last Democrat chair of the SEC, Mary Jo White, the commission adhered closely to the statutory authority of Congress. During her time as chair, 59% of the SEC's proposals were mandated by Congress. By contrast, under your leadership, only 17% of the commission's proposals are mandated by Congress, according to a report from Professor Hal Scott of Harvard. Why is there such a rush under your chairmanship to promulgate so many rules without specific mandates from Congress?
It's because technology and the markets have changed so much. She was coming in as chair right after a financial crisis, so naturally there was, I think, 120 mandates that Congress placed. But you're accurate. We picked up about 10 of those from Dodd-Frank, one from the
So-
Holding Foreign Companies
So,
Accountable Act.
Chair Gensler, there's a perception that the SEC is neglecting public input, and particularly from bipartisan letters that the members of Congress have sent to voice valid concerns regarding individual rules and the rulemaking process. The concerns encompass the bipartisan concerns about insufficient comment periods and a general response to bipartisan concerns regarding proposals on swing pricing, liquidity risk management, and equity market structure. Are you aware of similar bipartisan concerns being raised with previous SEC chairs? If not, could you elaborate on why the opinions of Congress don't factor into your considerations?
Well, the opinions of Congress most definitely factor into my consideration.
It
Like
doesn't
this
seem so,
conversation here.
Mr. Chairman. It does not seem so when only 17% of the proposals that you have brought forth are the result of mandates from Congress. I find it incredibly frustrating that anytime we provide comment or send what we call strongly worded letters about our opinions on how the SEC should behave, it seems like these must be immediately thrown in the trash and disregarded. I want to turn to Reg SCI. The SEC originally adopted Regulation Systems Compliance and Integrity, otherwise known as Reg SCI, in 2014 in response to several market disruptions at national securities exchanges. Earlier this year, the Commission proposed to expand Reg SCI to certain broker-dealers. However, unlike in 2014, the Commission fails to provide a single instance of a broker-dealer systems disruption that had a significant market-wide impact in the securities markets. In fact, the SEC's own proposal acknowledges that broker-dealer systems performed well during the unprecedented trading volumes and volatility at the height of the COVID-19 pandemic. Further, the Commission admits that it, quote, finds it impracticable to quantify the many benefits associated with amended Regulation SCI. Once again, this seems like the Commission is providing a solution in search of a problem. Chairman Gensler, given that the Commission cannot point to a single broker-dealer systems disruption or any tangible benefits to applying Reg SCI to broker-dealers, how can you justify that proposal?
As we outlined in the proposal itself, which is still out for public comment, some broker-dealers may have the size and scale and standing in the markets that if they were taken down, that could be disruptive to the markets. That's the important thing. And this so-called systems compliant integrity is about those most consequential or central parts of the market.
The SEC's RegFlex agenda for 2023 indicates you intend to finalize proposed rulemaking to expand the definition of an exchange in short order. Although the SEC has reopened this rulemaking, the proposed rule is still fraught with insufficient economic analysis and ill-defining scope, among other things. Given Congress's ongoing and unaddressed concerns with the rulemaking, as well as concerns of hundreds of stakeholders, it seems irresponsible for the SEC to finalize this rulemaking. Could you comment on the expected timeline for finalization of this rule?
You'll be pleased to hear that we don't do it against a clock. It's really when we get the comments and the economics right and the legal authorities right, and then discuss it with the commissioners.
And finally, I want to raise an alarming issue that I think needs further attention: the timing of various actions by the SEC while Congress is seeking to establish a regulatory framework on digital assets. To name a few, January 12th, 2023, this committee announces the formation of the Digital Assets Financial Technology and Inclusion Subcommittee. It was subsequently announced that the SEC pursued enforcement actions against 2 firms. March 9th, 2023, the committee hosts its first hearing on the Biden administration's approach to digital assets. An hour before the hearing, you publish an op-ed in The Hill. April 27th, 2023, the committee hosts another hearing on digital asset regulation. You tweet and quote office hours video on your view that most digital assets are securities. May 3rd, 2023, this committee and the House Agriculture Committee, led by my colleague Chairman Thompson, announced our first joint hearing on digital asset legislation, which is unprecedented. You published another office hours. I'm not one to connect dots, but it seems like you're actively trying to undermine the work of Congress. You must not impede our work to do our job, even though you won't do yours. I yield back.
Boom. If the gentleman wants to respond.
I very much respect the work of this committee, and particularly the work of this committee around
You're trying to make your own rules.
assets. We have a robust
By the book,
time
scary.
because this is a field that's rife with fraud and abuse, and so our enforcement agenda sometimes does roll out while you're doing your good work here as well.
Mr. Ogles of Tennessee is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Gensler, thank you for being here. I do want to echo the chairman and support the chairman that, I think we've come to this crossroad where subpoenas may be necessary. It seems that compliance and requests for information and documentation has been kind of shortcoming. And so with that, Mr. Chairman, you have my full support as when and if you decide to move forward. But Mr. Gensler, I want to kind of, one of the things that concerns me is sometimes the subjective or what the perception of subjective and arbitrary nature of the rules. In May 25, 2022, the SEC proposed amending the names rule to further regulate the names of investment funds. Well, I think everyone would agree that it's misleading of a fund called the Mexico Growth Fund made most of its investments in Japanese value stocks. Many names may be subject to differences of opinion. The proposal specifically mentions ESG funds. Mr. Gensler, is the SEC equipped to determine what, broadly speaking, is good for the environment as it pertains to ESG?
No, sir, we're not an environmental regulator.
So again, going back to the subjective nature of some of the rules and the compliance that is forced, I mean, it's kind of like what's better than environment, paper, or plastic bags. So when we should be focusing more on the fiduciary aspect of a fund versus its environmental compliance concerns.
About 2 hours.
When you look at the social component of ESG, who would you entrust or how will you determine whether or not a company is compliant with the social portion of ESG?
So in terms of this names rule, it was basically truth in advertising, that if you're going to say you're a social fund, to use that, you have to actually then describe what the marketer of that